Okay, good afternoon, ladies and gentlemen. So, we now discuss international commercial dispute resolution. In this case, in this class, we refer to some of the cases missed in last class. See, projection. The topic was presenting. I missed inserting the case. However, you now can identify cases on printout. The first case, L5 View Company, versus Atlas Copco AB, decided in Fifth Circuit, and also Perox Bank versus Russian Savings Bank, also in the new beginning, new millennium. And one other case is entitled Capital Currency Exchange versus National Westminster Bank and Barclays Bank. In that case, you see a case highlights, which is in summary, a short case. You see, for example, you will be aware the law for a call to dismiss case on the forum non-convenience doctrine. It must determine that an adequate alternative forum exists. So it's conformed in the last class. And the unavailability of certain remedies under the laws of the alternative forum does not render that forum inadequate. So actually mutually effective and competing in terms of a exercise of jurisdiction. And also you see the case titled Nelson Bunker Hunt versus the VP Exploration Company. It follows the famous case, which is leading in this area of issue, the rule of reciprocity, whether the court has respect the rule of reciprocity in recognition and enforcement of foreign judgment. So as you see, one of a meaningful international agreement about enforcement of foreign judgment. So it was rewritten to abandon this rule. Right? So now that position was also supported by a National Court of the United States. However, in this case, as I mentioned in the last class, was not granted the enforcement since it is pending status and now waiting for the final decision by the House of Lords in Great Britain. And in the last class, titled Yahoo Incorporation versus Larry Control the Racism and Anti-Feminism. So this case actually posing challenges and has undergone extensive criticism and also the voice of support by global public. You see, it essentially involves a kind of a First Amendment rights in the United States. However, the context is very transformative, as you see in the advent of e-technology. So internet, Yahoo. Yahoo is actually most powerful and dominant business in this area, you see. And I also see your routine day is be entertained in your PC, or so often we spend many of times routinely in subscribing to internet sources, you see. So it is actually impacting if we regulate the internet businesses in not committed way or in any one-sided perspective, national. However, we also verify kind of territoriality principle, often seen more determinative than any other consideration. In this case, the United States court disposed in that way, and actually denied the French order about the displays of Nazism or some scenes of atrocities, and you see some rule about direct effect or others in assessing the kind of value or merit about and also relevance about recognition or enforcement of foreign judgment. So commercial activities, as I said, is one of notable exception to grant a jurisdiction involving a state government entity, governmental instrumentalities or others, and also other requirements attached to make the exercise of jurisdiction valid. So what a direct effect in the territory of nation, specific nation. So the United States Court often invested kind of a directive, which means legally significant effect, you see. This case may arise in some perverted way about the concept. And what we see, the word global village, have you encountered the word global village? That concept is now very extended if we identify the trends of a global interplay. The internet sources are now actually omnipresent and now often engage in some of global impact. So a physical presence has no longer be meaningful. As you see, for example, there is little doubt that internet users in the United States routinely engage in speech that violates China's laws against religious expression, the laws of various nations against advocacy of gender equality or homosexuality, or even the United Kingdom's restriction on freedom of press. So, actually, Nazism is one of the worst displays of inhumanity or a cruelty, kind of, and France was directly affected in the warfare of a World War II, or as hate speech, violent expression is kind of was trend to affect the nation seriously, and also very contrary with the public policy of France. So the French Civil Code has taken the measure to respond with this kind of a internet provision of seeing or the kind of expressions. So the tension may underlie between the freedom of expression, which is actually most sacred, as you see in the order of provision amendment, the First Amendment right. The founding fathers of the United States actually see it most essential and fundamental to construct a new republic in the continent. And along with this First Amendment, you see the classic set of a liberty and a human rights, what we often call Bill of Rights. And the First Amendment, along with the equal protection embedded in the 14th Amendment in the United States, actually are a most popular subject litigated in the courtroom of the United States. So actually, we may mention about internationalism. Some critic may raise kind of international constitutionalism. And also, we have many versions and propositions often challenged by nationalists or others. So kind of a structure in controversy and exchange of ideas would be framed into this kind of a concern, you see. So actually, the core reasoning as you conform over the pages is lengthy, which looks like some kind of harangue about a comity and the due respect to French authority. Wrong is, however, actually the court was disposed to see the essence of a First Amendment, which centers on the democratic demand requirements, as you see. According to the court opinion, this case is not about the moral acceptability of promoting the systems or propaganda of Nazism. Most would agree the subjects are profoundly offensive, kind of hate speech, offensive expression, and also the kind of a concept between content neutral or content-based regulation may be pertinent, you see, in the constitutional class. And libel or defamation, also one other class to come into play in this area. So we have some rules of which of states is the kind of content-based regulation. So content-neutral regulation will be afforded more chances to survive. It actually neutral and politically not subject to public suspect, you see. So the court often be generous about content neutral regulation. So, place and manner and time restriction often be the factors in way on which the public policy makers design their policy design. So the policy frameworks actually more acceptable ways to deal with regulation of expression of speech. How do you consider the hate or violent expression? See, This code is actually mindful of the emotional pain, reminders of Nazi Holocaust to Holocaust survivors, and deeply respectful of the motivations of French Republic in enacting the underlying statutes and of defendant organizations in seeking relief on those statutes. Vigilance is the key to preventing atrocities such as Holocaust from occurring again. So you see, in practical point about this case lies in intrinsic difficulties about internet technicalities, you see. If Yahoo complies with the order of a French government, the response would require extensive repair. For example, they could not handle the order without banning the whole of expression, which would be global. So it leads to banning Nazi-related material from Yahoo altogether, dismantle altogether, abolish the expression, which could be impacted globally. How do you consider the context of effect in compliance with the French code, French criminal code? And actually, the French order was imminent to enforce its mandate within the territory of the United States. So it is posing challenges practically and actually for Yahoo business. Okay. So Yahoo business initiated to seek a declaratory relief about its validity of expression and which need to be safeguarded upon the commitment of First Amendment framework. So it actually stirred the circle of legal scholars in this area, and very representative and leading cases in the face of a new global age. The French code in this case found the approximately 1,000 Nazi and Reich related objects, including Adolf Hitler, Mein and Kampf, the Protocol of the Elders of Zion, an infamous and anti-Semitic report produced by Tsarist secret police in the early 1900s, and purported evidence that the gas chambers of the Holocaust did not exist or being offered for sale on Yahoo.com's auction site. Because any French citizen is able to access these materials on Yahoo.com directly or through a link on Yahoo France, the French court concluded that the Yahoo.com auction site violates section R645-1 of French Civil Code, which prohibits exhibition of Nazi propaganda and artifacts for sale. On May 20th, the first year of new millennium, the French code entered an order requiring Yahoo to eliminate French citizens' access to any material on the Yahoo.com auction site that offers for sale any Nazi objects, relics, insignia, emblems, and flags. And second, eliminate a French citizen's access to web pages on Yahoo.com displaying text, extracts, or quotations from Mein Kampf and a Protocol of the Elders of Zion. And third, post a warning to French citizens on Yahoo France that any search through Yahoo.com may lead to sites containing material prohibited by Section R645-1 of the French Civil Code, and that such viewing of the prohibited material may result in legal action against the Internet user. The author subjects Yahoo to a penalty of 100,000 euros for each day that it fails to comply with the order. Yahoo subsequently posted the required warning and prohibited postings in violation of Section R645-1 of French Civil Code from appearing on Yahoo France. Yahoo also amended the auction policy of Yahoo.com to prohibit individuals from auctioning any item that promotes, glorifies, or is directly associated with groups or individuals known principally for hateful or violent positions or acts such as Nazis or the Ku Klux Klan. Official government issued stamps and coins are not prohibited under this policy. Expressive media, such as books and films, may be subject to more permissive standards as determined by Yahoo in its sole discretion. Notwithstanding these auctions, the Yahoo.com auction still offers certain items for sale which appear to violate a French order. So, actually, in this area, you may find kind of a ethos about a competition of laws. You see legal pluralism. You may know the legal pluralism, or diversity in legal culture, the kind of concept. Actually, law is one of national expressions about its culture, attitudes, and the tradition of or history of the specific nation. So we now see the kind of stark contrast between gender issues. For example, you see some of approaches which could not be comprehensible by a Western standard of eyes. Perception would fairly differ in some cases. So they may consider it proper that the female person must be masked on her face, or may be stoned if she commits adultery to death. So they may accept the kind of social custom as their own, or you may have the word a theocracy. It may interact in superiority over the constitutional arrangement. Also, we may have some lesson from the working. Have you known Nate Dworkin, who is actually a very ambitious lawyer? He also empire of law. And in the circumstances where we live in a diversity of legal culture, we may find some of values shared in universal commitment. Actually, how do you perceive the strengths of a communal tradition about the concept? And the competition of law concept in relation with the substantive laws often be realized in practical way about a procedure. So international litigation often may pose challenges, as we see in Yao case or others. So what is concept? Actually, territorial principle may come first priority. However, we see some concept about international comity. However, it is not exactly the requirement stemming from the rule of law. It's just the concept to be recognized in terms of a convenience and expediency kind of respect or difference. So it may not bind in any mandate about the national court and judiciary. So, however, it is concept to recalls if we are posed with kind of a controversy of this area. And also, I remind the commercial arbitration is the most popular way to deal with a dispute, the international dispute, which is private also. And in understanding the rule about this area, you need to have awareness about due process terms and also the kind of a new dealings, a long arm statute. Of course, the statute was developed in inculcation, of a case series in which you will see the international issues case, which is actually founding leading to the legislation of long arm statute over various states. And also the code has developed what I have mentioned about sanctity of a sanctification of statute. So the code actually accommodated both concepts into two special strands about varied jurisdiction, a subject jurisdiction and specific jurisdiction are actually a point you need to focus in dealing with this question. A specific jurisdiction arises if the entity purposely avails of its commercial incident and minimum contact may be verified by a court perspective, you see. So the litigation results from alleged injuries that arise out of or relate to those activities. From the purposeful contact and with the forum state. And also general jurisdiction requires that the minimum contact has to be continuous and systematic and substantial. So actually we have a beginning point about impersonal jurisdiction. So defendant might be the resident of a forum state, and in Roman tradition it was embedded that the defendant was a passive party who deserve a due protection in terms of a civil litigation, you see. So proper notice and service of process has to be ensured to warrant the traditional notion of fair play and substantial justice. The point was actually critically elicited to make an impact on subsequent cases in international issue case. And in the case entitled Alpha and View Company versus Atlas Copco AB, you see the contention and argument raised by a defendant about specific jurisdiction and the stream of commerce theory. In this case, the forum called was with the Federal District of Texas, and actually the defendant was a subsidiary company, what you call so-called Unilac AB, Unilac, and there is a parent, international parent company who owns the stocks and this company, which amounts to 100%. So actually, we may have some ideas about identical treatment. How do you consider? However, the court perceived as differs, you see, and 100% of ownership about the child company in Texas are not alone sufficient to afford a same status between international parent company and a child company in Texas. So we have to convince some other independent grounds to make the child company as a defendant and might be subject to the jurisdiction of a local court. How to consider? And also we have a theory about corporate bail. In some cases, the justice will require to pierce the corporate bail, and which leads to actually disband of that independent ground and merged into a kind of a basic frames of a civil justice. This case shows the point in contrast, very in contrast, and the court affords a more strict viewpoint between two entities, so which should be treated differently in strict terms. They are independent entity and must be established of about separate grounds to make the local court exercises jurisdiction. So the court negates the competence of Texas court in dealing with this case. The defendant raised the theory, what we call the string of commerce theory. And in the argument, this theory may apply and specific jurisdiction may be found established. How do you consider? The court would think the stream of commerce theory would not apply, and actually entails some vulnerable aspect to afford to grant the competent jurisdiction of Texas. Appellants rely heavily on the stream of commerce theory. In support of their argument, the stream of commerce theory is applicable to cases other than those involving a product's liability. Appellants point to courts applying the theory to cases raising antitrust or intellectual property related claims. When a non-resident contact with the forum state stems from a product sold or manufactured by the foreign defendant, which has caused harm in the forum state, the court has specific jurisdiction. If it finds that the defendant delivered the products into the stream of commerce with the expectation they will be purchased by or used by consumers in the forum state. So it actually connotes in a slim sense about a contact or a relationship with the forum state. And often the kind of theory may be more plausible in the context of product liability. As you see, the product liability is a new version about in response with the capitalist development of economy, you see. So the superiority in bargaining power or the disparity in economic status warrant is new rules about product liabilities, kind of new response, a shift of burden of proof, what is, or in some cases may operate in terms of a determination of a competent jurisdiction, you see. So actually, they are powerful to relate with a global market, and they will be expected to envisage the kind of a probability which requires them to respond with the court proceeding in some other distinct foreign states. How do you consider this theory in relation with this case? This theory is not a product liability issue, and breach of contract, which was titled 1992 Intentional Agreement. So appellants argue that putting products into stream of commerce with the expectation that Texans will purchase or use those products suffices to establish jurisdiction with respect to any claims. And the logic and metaphor of this argument is more akin to a general jurisdiction argument than a specific jurisdiction argument. And also the court denied this argument since appellants make no attempt to link appellant's contact with Texas and the instant litigation. This is a link that a specific jurisdiction requires. And also, court's rule, appellants have not asserted that the alleged misdeeds occurred in Texas or that the 1992 agreement was negotiated or executed in Texas. Neither Alpine View nor Hansen is considered a Texas resident. And also, you now need to know the Alto-Ogo doctrine, which eventually was rejected by court. This doctrine is actually preeminent in the area of corporate laws, you see, and might be well perceived in understanding the corporate identities concerning legal terms, you see. Appellants, in asserting this doctrine, must make a prima facie showing that ACAB controls other organizations, that the activities of those organizations may be fairly attributed to ACAB for purposes of asserting a jurisdiction over it. Under Texas law, the alter ego doctrine applies when there's such unity between the parent corporation and its subsidiary that the separateness of two corporations has ceased, and holding only the subsidiary corporation liable would result in injustice. And the court also confirmed my previous statement about the extent of these rules. And so now the corporate form is one a notable expression of a global commerce, and the commercial activities issued by corporate entity. And all you see types of business entities in the framework of a commerce. However, the corporate entity would be most powerful way to execute a grand scale of businesses. However, in this internet era, you also see some of tendency, as I have said previously, about unlimited liability corporate form, which is new in quality, and that raises an business ethics, kind of a fiduciary duty of the concept. And also the theory of corporate law need to be seriously investigated in terms of a fair justice. You see, and the national policy about the fair trade and anti-competition. So how to preserve the level playing field in this new state of a social justice, notwithstanding the predominant ethos of liberalization. For example, corporate bail doctrine may be actually marginalized in application. However, some fundamental way in extreme cases and upon a serious findings about injustice may be applied in some cases. So this case actually was concluded that the district court did not err in dismissing appellant's claims against Robbins and ACAB for lack of a personal jurisdiction. And also, you see the interesting case titled Parox Bank versus Russian Savings Bank. This case involves the contracts between a sovereign entity, Russian Federation, and the United States Corporation. And the Russian entity breached the contract not to credit the required sum in the account, a bank account located in New York. So then we consider the state immunity the statute, FUSA, and also some case law rules and principles about commercial activity and direct effect. The act at issue here, ShareBank's failure to deposit funds into Parox Bank of New York account arises out of a deal transacted outside of the United States in Moscow and Riga. Despite the fact that one of the parties to the exchange was a foreign state, the rubles for dollars exchange at issue here was conducted at a private transaction and rather than as a public service, and as such constitutes a commercial activity. And in dealing with this case, we have some influential precedent which fit within in close bearings with this case. The case titled Hanil Bank, which is a Korean bank, you see. And in this case, the counterparty who entered into contract with Korean bank also defaulted to credit the terms into bank account of New York, located in United States. In this case, by contractually consenting to pay the funds into plaintiff's New York account and then failing to do so, the court held the Indonesia bank caused a legally significant direct effect in New York. So actually, we may also consider kind of AD doctrine, which requires the federal district court to apply the state law where they sit in. So the context would, however, not be dissimilar across the various states in the United States. This case typically addressed to the New York jurisdiction, and the president led by Hanil, the president involving Hanil Bank elucidated the ways the court has to be disposed of. So the parties contract their location outside the United States. The monetary deposit would be made by one party in the other party's New York bank account. As in both Weltover and Hanil Bank, money that was supposed to have been delivered to New York Bank for deposit was not forthcoming. So one other exception about direct effect would not be satisfactory to warrant the state immunity. So the court found affirmatively that the enforcement may be afforded. So the sovereign immunity would not be afforded to the Russian savings bank by way of operation of a direct effect rule. So you consider several points. It lists the essence of a case. So that will be all for this class. Actually, how do you consider the recent call about unification of homeland? We Korean people now suppose unification of nations, 75%. So actually, we may be properly disposed as philosophically conservative and practically liberal. We once have a political share about a new right, Korean writing. How do you entitle the status of Korean right? Often now we can witness the kind of a right-wing trend in international politics, particularly within the East Asian region. The daughter of former President Kennedy was appointed as an Japanese ambassador, and Japan and the United States may make into new relationships. How much it is plausible to sail back, at least the one leader of right-wing Korea, is a vision and ambition about unification of Korea. It is practically possible. Actually, we also track some of intense intensity and persistence about the conservative fathers in Korea who have many opinions about sensitive public issues and others. Interesting. Okay. If you don't have any questions, I now will close class and see you in the next class. Thank you for your attention.